In the last video, we talked about representing your clients competently. Now it's time to talk about Rule 17, conflict of interest. Now let's be real, we're lawyers, not slaves loyal to only one slave master. At some point, we'll have a lot of clients, and it's not outside the realm of impossibility that these clients may clash, hence a conflict of interest. So what does the RPC say? If you are representing a client who has retained your services for a particular matter, and the opposing party is also a client you've worked with before on the same matter, you have to tell your new client about this. By doing so, you are giving your client a choice to either retain your services or choose another lawyer for this particular case. This is more ethical than keeping quiet about it, because the opposing party can use it as an advantage against your new client. It's also possible that the matter can involve your own financial, proprietal, or personal interest, which in turn can affect your professional judgment. An example of it affecting your personal interests is if the case affects your family member negatively. If by chance the matter happens to affect those interests, don't accept a retainer unless the client consents to you representing him. It's important to note that this applies where the lawyer has a special retainer with the client on a particular case, not a general retainer for ongoing legal services for a specified amount of time. So for example, if clients A and B have a contract and there's an issue, you can't represent both of them on a particular matter because there will be a conflict of interest. However, if you represented client A in a matter, and then you are also representing client B, but not on that same matter or something related to that matter, but just on a general retainer, even if you've worked for both parties, there is no conflict in this case. Another highlight is that you can't acquire property which is a subject matter of a case you are conducting for your clients, because that will conflict with your client's interests. The exceptions are when you want to acquire a lien to recover your legal fees and expenses, or when you contract with your client for a reasonable contingency fee in a civil case. Another highlight of this rule is that you can't represent two clients in the same matter at the same time unless you've discussed with both parties and they both consent to such representation. It's very possible to see this kind of thing happen in a contract of sale of land. An example is when a solicitor makes a sale of land agreement for both the vendor and purchaser, and both of them rely on his legal advice. Also, if you're a party to a case and your client is the opposing party, you can't appear as your client's lawyer. Finally, when a lawyer declines employment or withdraws from the client's case because of this conflict, a partner, associate, or any lawyer connected with you or your firm can't accept or continue that particular case. And with that, we've come to the end of Rule 17. The next is Rule 18, which talks about agreement with clients. Thank you very much for watching, guys, and remember, stay lawful, stay informed.